Trial attorney and legal analyst Brian Claypool is joining us now. Brian, I'm glad you're here on this because I'm just being told by our producer that apparently the gag order hasn't ended. And I want to ask your insight about this because this is confusing to me and it's counter to a lot of what I've been hearing. But apparently in an interview, on another network, a Trump lawyer, Todd Blanche, answered a question about this. And he said, I'm not really allowed to comment because we are still under a gag order. Brian, can you help explain this?
Hey, Natasha, great to see you. Yeah, the court still has jurisdiction of this case. Trump's legal team is going to be filing motions in the coming few days, I would think. One of those motions is going to be a motion to vacate the verdict based on a lack of evidence, just to give you an example. And there could potentially be a motion based on what Trump's legal team finds out about the juror deliberation. So after any jury trial, lawyers can hire somebody to go try to talk to the jurors about what happened during deliberations to try to form the basis for having a conviction overturned. So those motions have yet to be filed. Judge Merchan has not ruled on them yet. So technically, the case is still pending. And then you have a sentencing on July 11. So that's probably why the gag order is still in place.
Interesting. So do you believe the gag order will likely still be in place until July 11th then? Is that right?
Yeah, that's my belief. Because the judge still has to rule on post-trial motions leading up to July 11th. Personally, I don't see why you need to have the gag order in place up until July 11th, because the whole purpose was to not intimidate the jury, remember, to secure juror safety. And that's the case is over. The jury has spoken.
And Brian, I know that Trump, of course, already promising to appeal this right away. What are the strongest grounds do you think he and his team has for an appeal here?
Yeah, Natasha, I've done over 50 jury trials, and I have to tell you that in my opinion, there were some flagrant constitutional violations that are going to lead to what could be a very viable appeal. The first one that stands out is Trump allegedly not being informed of the actual charges against him. You have a constitutional right to know exactly what the legal charges are against you. The indictment didn't mention anything about federal election law violations, state election violations, tax law violations. In fact, we didn't find out about the second tier of alleged crimes until closing argument. That deprives, arguably, Trump's legal team from putting up a bona fide defense. That's the first one. Second one is this issue of not requiring a unanimous decision on the second crime. Remember, there were three categories. Judge says, oh, you don't need to be unanimous on what the second crime is. I think that's going to be looked at very carefully by the New York appellate courts. And then putting aside the two constitutional arguments, you got three or four other arguments. This judge didn't allow Trump to call an expert witness to refute the claim that this was a federal election violation. Trump wanted to bring in an expert to talk about the Federal Election Commission and how the facts here do not support an FEC violation. Natasha, in my entire career, I've never seen that. That's what experts talk about. That's what they speak to the jury. And Trump was deprived of having an expert talk about that. And then you've got three more grounds dealing with evidence. You've got the evidence coming in from Stormy Daniels, all the salacious details of how the sexual encounter happened, including, arguably a comment by her that she felt intimidated by Trump with a security guard there, which could intimate to the jury that this was non-consensual sex. That's another one. And then you got the Karen McDougal evidence that came in, and the jury was asking about that. That's prejudicial. It's not probative. Trial judges, Natasha, have to first analyze, is this probative? Is this relevant? Even if it's relevant, if it's prejudicial to a defendant, you keep it out. So there are, at least, 5 or 6 grounds for an appeal. And getting to your other question, you were asking your other guests, I mean, this could take a year, 2 years, depending, for example, what the New York Court of Appeals does. You've got to go through New York first. What if they reverse? That could happen in the next few months. If they don't, this could go all the way up into the federal court system then, where Trump's going to file what's called a habeas corpus petition in a federal district court. And even if that's denied, Natasha, Trump can go all the way up then to the U.S. Supreme Court.
Okay, so one more question for you. If Trump were your client, he is set to, take the stage publicly and make a statement in about 38 minutes or so. What would you be advising him, given the gag order has not been lifted, sentencing has not come down on this? What would you advise him, and what do you think we are likely to see this morning instead?
Yeah, great question, Natasha. I think there's a real client control issue here. I would tell him to stop talking about how the trial is rigged, how the judge is corrupt, because think about it. This same judge on July 11th is going to be sentencing you. So maybe tone down the rhetoric about how bad you think this judge is. I think what Trump should do when he speaks at 8 o'clock Pacific time, 10 your time, he just needs to talk about how he felt like the process was unfair and then move on. Move on to the election. Talk about what you're going to do, if you become president. Talk to your donors about fighting this alleged injustice. But continuing to impugn the court, impugn jurors, isn't going to do any good for him come July 11th, Natasha.
Okay. Brian Claypool, it's always good to see you. Thank you so much for your time.